Welcome to Estate Planning with Bernard Law.
Welcome to Estate Planning with Bernard Law with attorney Daniel R. Bernard, founder of Bernard Law PC, serving clients across Long Island. Dan focuses on creating customized estate plans to protect your assets, minimize taxes, and ensure everything is handled as you intend. I'm Leann Lyon, and today we are talking about estate planning for blended families and how to avoid conflict and unintended outcomes. Hello, Dan.
Hello.
Dan, what makes estate planning for blended families different from a more traditional estate plan?
So with all of my estate planning clients, my first question is, what are your goals with the estate plan? And I would say with blended families, their goals with their estate plan are often different than the goals of a more traditional family, for lack of a better term. Because in our traditional families, typically we think of, okay, we don't know who's going to pass away first, mom or dad, but we want mom or dad to probably use all of those assets. And then we expect to inherit something maybe when our second parent passes away. But in a blended family, our parent may pass away and still have a spouse who is not our parent, who they want to benefit from some of those assets. And then it begs a lot of uncomfortable questions like, well, what happens when that spouse who isn't my parent passes away, that has been using my parents' assets? Where are those assets going? So that's usually a key with the blended families, is their goals are just going to be different just based on the family composition.
So what kind of issues tend to surface in blended families when there isn't a clear plan in place?
So one of the biggest issues is housing, because typically we've got housing can have a couple different problems. One problem can be, your parent passes away, they owned the house. And that partner they were with, whether they were married to them or not married to them, doesn't own that house. And my parent passed away. That house is a significant asset. I'd like to collect on that asset, but this person, this is their home. I lived here with your parent for 10 years. Maybe I took care of your parent at the end of their life in this house. And now you're telling me to get out? This is uncomfortable. Or you have the situation where, okay, they mom remarries, and mom and new dad, or new whatever you want to call him, they buy the house together. But now mom passes away. Now you own a half of a house with new dad. How does that work? Maybe I want out of that house. Maybe I don't want. Maybe my mom has married someone much, much younger, and now I'm looking at, wow, this step parent is only a few years older than me. I may never inherit from this house. So houses are usually a big contention, because that's our homestead. That's where we live, and a lot of people, regardless of their ownership of it, they feel like that's their home. So that's where I see a lot of the biggest problems when we don't have a plan in place. Is it's usually around the living situation.
It's already sounding complicated. So what happens under New York law if someone in a blended family passes away without an estate plan?
So under New York law, if you die without an estate plan, New York has an estate plan for you, and that it's called dying intestate, and that estate plan is based on who survives you. So if you're survived by just a spouse, no children, typically your spouse is going to get everything. If you're survived by a spouse and then children from a previous relationship, your spouse is going to get part of that estate, and the children from their previous relationship are going to get part of that estate. But it can be uncomfortable because it's a question of who's getting what part of the estate, who's stepping up to be the administrator of that estate. Is it me? Is it my parents' new partner? I'm sure I want to do it. I'm sure my parents' new partner wants to do it. So you have a lot of natural places for contention, and even though New York State law can be quite specific on what happens, there's a lot of gray area in there on the composition of the assets. And a lot of times, like I said before, the biggest asset will be the home, and I want to still live in this house, or and I want to, and my parent or the parent wants to live there, and I want to sell. So that's going to be usually a contentious point.
So, why doesn't having a will automatically just solve all those problems for a blended family?
So a will can solve a lot of those problems for a blended family if the will is specific. But a lot of times we'll see in wills that we don't always update our will before we after major life changes. So sometimes we're probating wills that are before this new marriage or before this new relationship. So there'll be terms in there that really don't make sense for the family anymore, and you might have that surviving partner feeling like they're left out in the cold, and that can go one of two ways. If your parent has not remarried this person, that person really has no rights. They're not a spouse. They have zero rights to inherit from your parent. If your parent has married that person, now that person has estate rights, and under New York state law, they can elect against your parent's estate, and they can get 1/3 of the entire estate. So it can, a lot of times people may think, okay, my will says everything's going to my kids, and my partner has a will that says everything's going to her kids. So we're going to respect each other's estate plans. And then one person passes away. They find out, well, I can get 1/3 of that estate. And now your partner's electing against your estate, taking 1/3 of the assets that you thought were going to your kids, just because you didn't plan for that contingency in your will. You didn't have a mutual waiver of estate rights when you got married, or you didn't put something in the will for that spouse, or you didn't put a poison pill in there so they wouldn't elect against your estate. Many things that you could have done that you didn't do, and now we're probating an estate that clearly is not going the way you wanted it to go.
Okay, I have to ask, what's a poison pill?
Oh, just a disincentive to challenging, a disincentive to electing against the estate. Sometimes we call them inter-arm clauses, but we can get quite creative when it comes to spouses and things we can put in there that may make them not want to elect against your estate. An example could be, say I own the house and my new wife just moves into the house. I could put a poison pill in my will that says, you can live in this house rent free for a year, but if you elect against my estate plan, you get nothing. So now you have to weigh, okay, do I want to live here and have housing for a year? Or am I going to elect against this estate and maybe get more money, but I'm going to be in a contentious situation and maybe I don't get anything.
Yeah, absolutely. And well, that's what I really do appreciate about really good estate planning is the creativity and flexibility of it. So let's continue. How do beneficiary designations and jointly owned assets override what someone thought their plan would do?
We see this unfortunately too often. So we'll see we'll see. Client will come in. Their will says, okay, give my house to my daughter, give my stock account to my son. And then we get to the stock account, and the stock account has a beneficiary, and it's the daughter. So now we have the daughter is clearly under the will. She gets the house. But beneficiary designations, they trump not a political statement. They trump beneficiary. They trump your designations in a will. So if you've designated as your beneficiary your son, but you put in your will, your daughter gets the account, your son is getting that account. The beneficiary designated gets that account. So sometimes when we update our estate plan, we're thinking about our global assets and we're putting everything in there, where we want everything to go. And we forget that when we signed up with E-Trade, in 2005, they asked us for a beneficiary and we put a beneficiary down and we never updated it. So it's important to make sure when we update our estate plan that we're also looking at our beneficiary designations, because that's a key component.
How often do you actually see that happen?
It does unfortunately come up because it's a lot of times people don't think of it as the same thing. A lot of people think of it as, well, I designated these beneficiaries because they told me to do it, fill out a form, and my estate planning is creating my will. And my will is going to tell everyone what happens to my stuff when I pass away. And that's just not the case. Your will is only going to control assets that go through the probate process. Anything that has a beneficiary, anything that's jointly owned is not going through that probate process. It's going to go directly to that beneficiary or directly to that joint owner, regardless of what your will says.
So, what are the key decisions someone has to make when they want to provide for a spouse, but also protect children from a prior relationship?
Number one decision is, how do I want to benefit that spouse, right? So there's a couple ways they can do it. One way is they leave some of the assets to the spouse, or they leave some of the assets to the kids. Another way is sometimes people say, well, my spouse really needs all of my assets to be able to continue our lifestyle, and I want her or him to continue the lifestyle, so I need to kind of leave everything to them. But I also want my kids to get this stuff. I don't want their kids to get it, or their heirs to get it, right? So we can do some creative estate planning, and we can set up what are called QTIP trusts, qualified terminal interest property trusts. In a QTIP trust, the QTIP trust says, I'm leaving all my assets into this trust for the benefit of my spouse. My spouse gets to use those assets. So if I have a house in that QTIP trust, she gets to live in that house. If I have a stock account in that QTIP trust, she gets all the income from that stock account. So maybe in retirement, we're living off of those dividends, we're living off of that interest, and she can continue to live off of those dividends and interest. But the key distinction in a QTIP trust is she can't change the beneficiaries of the trust. So ultimately, whatever's left in that trust when she passes away will go to where I want it to go. So typically that would be go to my children, right? So that's a nice way of kind of split, it's a nice way of meeting in the middle, in that we can benefit our spouse, but ultimately we're still going to make sure our kids end up with our estate at the end of the day.
Love that. How are these decisions actually structured in a well-designed estate plan? You talked about the Q-tip trust, but are there other structures that could be put into place?
Sure, I've done Q-tip trusts work really well for houses, but stock accounts, because the interest dividend component of you're getting the income, but you have discretionary access to the principal typically, but I'm going to pick the trustee who decides if you have access to that principal. But another way is, like I said, the biggest component in the blended family is often what I'm seeing is the house. So sometimes we'll have special trusts, sub-trusts within our wills or within our trusts, just dealing with the house, special kinds of residence trusts that are going to set the rules for the spouse, because I can say, okay, my new spouse can live in this house for the rest of her life, right? But that leaves a lot of open questions that can be uncomfortable, like, well, who's paying the taxes? Well, what happens if she lets the house fall into complete disrepair? What happens if who's paying the maintenance on this property? What happens if she wants to make a major renovation? What if she wants to convert the garage into another bedroom? What happens if she wants to rent the house out? What happens if she remarries and now she's moved a third husband into my house, right? Those are all things that we maybe don't think about, but I can promise you are going to drive your children crazy after you pass away. And I can promise you that the surviving spouse never thinks they have to pay for any of those things. This house is owned by a trust. It's not my house. Your mom, your dad said I could live here. I don't expect to pay any expenses. So typically within that residence trust, we want to carve out, what are the rules for this person living there? Like, can they cohabitate with someone else? Some of my clients, they don't care. Yeah, get another husband. Some of my clients, absolutely not. If she gets another husband, gets another wife, he's out of here. Who's paying the taxes? Who's paying the maintenance? Can they mortgage the property? What happens if they want to sell the property? Can they sell and purchase a new property? Or if they want to sell the property, that's when we're going our separate ways and my kids get to inherit at that point. A lot of different things we can do. And I guess the key is we want to customize it to what makes sense for you and your new spouse, you and your family. It's all of this stuff is customizable. What I tell my clients is, I've been doing this a long time, met with a lot of families. I feel like I've seen almost every kind of way we can do it. And I just want to give you the best advice on what other people have done. But at the end of the day, it's your estate, it's your decision, and you got to decide what's best for you and your family.
Can you walk us through an example where a blended family situation led to an outcome no one expected? And what could have been done differently?
I can give you an example of an outcome that no one expected except for me. But I'll see this often with the Q-tip trust. I will recommend in a blended family, let's set up a QTIP trust. Not that we think I don't think you would do this to each other, but you never know. Why even give incentives? This is definitive knowledge. You'll know this will go to your kids. A lot of times people say my spouse would never do that. I've had multiple estate plans where blended family, kids on mom's side, kids on dad's side. Dad passes away, mom comes back in. I'd like to update our estate plan. I want to leave everything to my kids. That's perfectly within her rights. I may ethically not agree with her. I may turn her down. I may say, I'm not doing your estate plan. But she's well within her rights to go to any attorney and update that estate plan. If all of those assets pass to her directly upon her spouse's death, those are her assets now. She can leave them however she would like.
That can be tough, but law's the law. So what should someone with a blended family make sure is clearly addressed in their plan to avoid confusion later on?
I think the best thing is do the planning together. So when sometimes I'll have blended families that come to me where just the husband or just the wife wants to do the planning. My wife isn't interested. My husband isn't interested. That can be a challenge because now they don't really know what you did. You haven't worked collaboratively. When you come in that situation, you're probably going to be more guided towards benefiting your kids than taking care of this spouse who's refusing to even sit in an estate planning meeting with you, right? So it can cause problems there when we're not doing this planning together. I like a plan where we both have decided, here's what I want to happen to my stuff when I pass away. You know what's happening. I know what's happening. And we've drafted these documents where after I pass away, you can't change what I've done. I know what's going to happen to my stuff, and vice versa. What's good for the goose, good for the gander. I'm not picking on, wives are going to live longer or husbands are going to live longer. We never know who passes away first. I've got lots of people come to my office. When my husband dies, I'm going to do this. We don't know. We never know.
Well, that is it for today's episode of Estate Planning with Bernard Law. If you'd like to learn more about Daniel Bernard and how to create a customized estate plan that protects your family and your assets, visit bernardestateplan.com. Thank you for listening, and remember to subscribe, share, and leave a review so more people can get the clarity they need when it comes to estate planning. Thank you, Dan.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.